Hello, everyone. How are you all doing today? I'm attorney Nicole Gaither. I am the owner and founder of Creativa IP Law. We strictly do trademark law. We help professionals to help build their brands, to protect their brands, to grow their businesses so that they can focus on building a legacy. So I am here today. It's Friday. I did not do my Tipsy Tuesday on Tuesday because I was trying to work on some great project that I have coming out that I'll be rolling out very soon for you all. However, I will be doing my Tipsy Tuesday next Tuesday. So if you have any questions or if there's anything that you want to address, please feel free to contact me. You can, send me a direct message, or you can, post your question on this page, or you can go to my Facebook page, which is called Speak Easy with a Copyright and Trademark Attorney. Join the group. You can, of course, use my website, creativaiplaw.com, or on Instagram, which I am trying to get better at again. I was there like every single day and then kind of fell off, so it does happen. It's Creativa IP Law or Trademark Law Diva. So now that we've gotten all the introductions out of the way, let me get to a question that I probably have gotten at least 5 times in the past 2 days. And this is, before I usually get like, hey, so-and-so referred me to you, or I saw you on Facebook, or I've been following your page, all this other stuff. And I appreciate it. Thank you so much. Thank you for reaching out. But usually the next question is, how much is it going to cost? And I get it. Most of us are on a budget. Like, nobody's trying to spend money that they don't have. It's not like one of those things where it's like, I'm required to do this. Like, it's not like car insurance. Like, I'm required to have car insurance because it's the only way I'll be able to drive my car. It's something that is highly suggested, recommended because of the benefits it gives you. So let's kind of start off first. If you're going to file for a federal trademark registration, you need to file with the USPTO. That's the U.S. Patent and Trademark Office. They do charge a filing fee. They charge a filing fee based on the number of classes that you file under. So that is basically the goods and services that you are offering. So if you are a coach and you're offering coaching services, that's one class. If you're offering books and downloadable products, that's another class. So you might have to file for 2 classes for your registration, for your application. Filing fees start at $225, which is the basic application, which, you're kind of stuck with whatever description the USPTO allows you to use. And it's kind of like, it is what it is. There is a higher cost application, which is $400. That is a paper application, which after October 5th of this year, you will no longer be able to use because USPTO is going all electronic for efficiency reasons, which might mean that they might actually do a trademark application faster than the 6 months to a year that they've been doing. And I do have to admit that they have been much better because I've gotten an application approved within 5 months just last week. So yay. Anyway, so one application that I tend to file with my clients that I generally, I'm going to say always file with my clients is the middle one. It's $275 per class. It allows me to actually be free with the description as long as I'm within the proper classification of goods and services. So I can actually, tailor the description properly to what my client is selling or, offering as services. And the one trick that I just found out about that I saw on the USPTO website that I've been using but didn't even know I could, is that if you file your application, you can pay for one class. And if you have multiple things in there that actually fall under different classes, they will let you come back later. They'll let you know, and you can pay for those classes later. It's like the USPTO class layaway plan. So share the love, share the secret. Anyway, I'm so glad, I wish I had known that, but I've been doing it anyway, so it's not illegal anymore. Anyway, see, there are things that I get excited about. So, of course, like I said, there's your filing fees. Of course, if you're not ready for that, there's the free option, which is once you start using your brand name, your product name, your service name to sell your goods and services, you have a trademark, because a trademark is basically a mark that is used in commerce. Like, it's the mark that you're using to trade. You have what's called a common law trademark, which means that you have that mark that represents your goods and services, like your, whatever you're using it for, but you are limited to what rights you have in that mark. So you are limited to just in your state. So if you came up with this great unique name and it was like, I have this great unique name and you live in Texas, well, somebody might have that same great unique name for the same goods and services and they live in Montana. You in Texas cannot stop them in Montana from using that name because you are limited to just your rights in Texas because you have not filed a federal registration. There are also risks to this because, first of all, somebody who has a similar mark, like I said, could go ahead and register their mark before you, which means that either if you now have to figure out, were they using the mark before me and now I have to rebrand, which can get expensive, and we'll talk about that in a second. Or if you were using it before them and they went and registered, now you have to prove to the USPTO that you've been using it first and they have to, their registration needs to be canceled. That's also a process. You might not even know that you're infringing on somebody's trademark because you didn't do the research, and now you're at the point where it might be too late for you to do anything with it, and again are rebranding. And like I said, you don't have national rights, so you are limited to just your state with that mark. A rebranding effort is pretty pricey because if somebody says that you can't use this name anymore, then you are going to have to, change the name of the Secretary of State. If that's the business name that you have, you need to contact the IRS, change your bank accounts, contact all your customers and clients and your referral sources, change your social media pages. You get rid of any products that have that name on it. You rebrand your services. So it could be a costly and time-consuming thing. So those are the risks that are involved with the common law free trademark. Then you also have the option of filing trademark registration in your state, which, again, limits you to protection within your state, but it's still more than just having a free trademark. I think that was thunder. It was kind of scary. Anyway, so state trademark ranges between $100 to $200. And again, gives you protection within your state, not really outside of your state, but at least you have some level of protection. Now, the question that I think people should be asking, which they're probably not even thinking about, is do I even need a trademark? And this is a secret that some attorneys are not going to tell you. You might not. It also depends on where you are in your business. So if you are, I'm not really dedicated to this name, I'm probably going to change it in a couple of years, then you shouldn't file for a trademark registration because you're not even, attached to that name. I call it are you married to the name? If you have a logo and you're kind of I don't even like it, I'm going to change it up, next year when I finally get some money to get somebody to design it, then don't file a registration for that because you're not even going to be using it past a year. A trademark is to be maintained and used forever. So if it's something that you don't plan on using forever and you already know that you're going to be changing it, then don't file the registration. But if you are just starting out your business, I call this the brand newbie stage, and I have names for everybody. So if you're just starting out, it's a side hustle, or you literally just went full-time with it last week, you just got your LLC, your EIN, and you are, just hitting up your social media pages and letting people know about your business, then that means that you probably are not, you don't really have the traction yet. You're just building up your clients, you're trying to get your market, trying to figure things out. You haven't really made that many sales and you're on a tight budget, then, this is probably the stage where you might need to wait to file for your trademark. Unless you have the budget for it and you started out knowing I'm sticking to this name, I'm moving forward, this is the name I'm going to get, I want it now, it's unique again, it's the best name ever, then if you have set aside the funds, then you should consider filing for that federal trademark registration to get the exclusive rights to use that name. It gives you exclusive rights to use the name, and then also it allows you to find out through the process if you are infringing on somebody else's mark so that you know early on if you need to kind of start from scratch before it gets very expensive. So if you're in this stage, you have the option to wait, you have the option to move forward, or you don't even, if you decide you never want to file for a trademark application or registration, it's up to you. So again, that's kind of we're at the beginning stage. So the growth stage, I call it making the brand stage. This is where you're getting steady income, your name is starting to get out there, your brand is building value, you're considering expanding into more product lines or service lines, or maybe even internationally. So you want to make sure that you have exclusive rights to that name. And then you also wanted to make sure that you're not infringing on somebody's mark, because now you have a name that's out there, and now you're finding out, oh, somebody else was already using the mark too. So, ooh, do I need to change my name, or can I work with this person? Like, are they going to let me exist and they exist, and we, decide, okay, you sell here, I sell there. I mean, you need to be able to figure that out at this stage, especially since you have gotten to the growth stage. And now it's going to be even more expensive for you to have to change your name if necessary. If you get an infringement suit or a cease and desist, you're going to have to stop selling your products. You're going to have to hand them over. You have to change everything. Like I said, social media, your IRS, EIN, all that. But you're also at the stage where you want to make sure that, copycats are not going to come after you, because like I said, you're building your market, you got traction, you got people who are coming looking for you. So you want to make sure that you don't have the person who was like, oh, I saw her website and I thought it was great, and I want her clients because she's got them. So I'm just going to set up my little website here and just add "the" to it and sell similar products and put similar labels on them. And now I'm going to get her clients. You don't want that. So again, this is the stage where I highly recommend that you file for a federal trademark registration. Again, you have the option to not file and take that chance, or you can wait even longer and take that chance, or you can do it now and, get that comfort and peace of mind that you've been looking for. So this is kind of the growth stage, which I call the middle stage, and it's my making the brand stage. See where I'm going here? The next stage, I call it brand heavy. This is where you're established, you have name recognition, you have sales, you have multiple service and product lines, you're in demand, people know you, you are out there, people just mention your name, your business name, and they're like, oh yeah, I already, I own it, all this other stuff. So this is the point where you definitely want to have exclusive rights, because, you might have copycats that are coming after you. Your customers, have let you know that they've been confused because they saw somebody else has similar website selling similar goods to yours. They have a logo that's similar to yours. So you want to make sure that nobody's going to take your name and nobody's going to come after you. You probably have somebody who is, like I said, imitating. You might even have counterfeiters. So, you kind of want to put that, you want to deal with that. So, and you also want to make sure that you're not infringing on somebody else's name. So this is, again, the stage where you need to make sure that the name that you're using is one that you are allowed to use. Because like I said, the rebranding is expensive and infringement lawsuits are expensive, because you do not want to have to pay damages, and you don't have to go through the whole cost and expense of having to change everything and hope that your customers and clients can find you with your new name. And again, you would have to change all your social media. So you hope that your followers can find you too. So I was looking at some famous rebrands. So I thought this was funny. So, you have WWF versus WWF. So you have the World Wrestling Federation, and then they got sued by the World Wildlife Fund. It's the people with the pandas and all of that. Well, the Wrestling Federation ended up losing. So that's why you now know the WWE. It's World Wrestling Entertainment, because the panda won. Anyway, so that was just a little information. So of course, the question you're saying, you know what? Okay, I'm going to move forward. However, I'm just going to save some money and do it myself. You have that option. You can do it yourself. However, there are statistics that say and show, and the numbers are I'm kind of sketchy on, between 60 to 80% of applications that are filed, by the person, without getting help, end up getting a rejection. And that's called an office action. So it's the USPTO trademark attorney actually sends you this document, depending on, it could be one page or it could be multiple pages with a whole bunch of evidence attached, depending on what the reason for your refusal is. It could be something as simple as you need to describe these goods and services better, or you need to pay for this extra class that you stuck in here, or it could be you need to disclaim it. And if you don't know what a disclaimer is, they're going to usually tell you, you need to say that you can't use the, you need to disclaim the right to use this word, or you might get rejected because your trademark doesn't operate as a trademark, it's generic, or it doesn't function as one, because that's what a lot of people are, getting when they try to trademark these catchphrases. This is kind of like what happened with Cardi B with her okay, or whatever, how you pronounce it. And then the biggest one is, a likelihood of confusion, which means that you have filed an application and are trying to trademark something that is already in use. And that means that you probably will not win that battle unless you can prove why you should be able to exist and this person should be able to exist, and that your customers will not be confused. And that is when you probably need to contact an attorney if you are ready to, if you want to continue moving forward and using that name, because an attorney is going to probably be able to tell you whether you should give up the fight because there's no way you're going to win it, or if they can help you, like they're going to give you they're going to work with you and, submit the arguments that are going to say why you should be able to use your name and this person should be okay with it. All right. Then there's the option, of course, there's LegalZoom and all these other paid services that, advertise doing like $200 trademarks and then plus the fees. So again, if this is the option you're going to use, but you just need to have the caveat of knowing that LegalZoom is filing your application based on the description that you are giving. So if you are not describing your goods properly because you didn't know how to do it properly, then if you are leaving stuff out, that means that you do not have the exclusive right to use your name on those goods. So if you're selling apparel and you leave out socks, you don't have the exclusive right to use your name on socks. You can still use it, but you're not exclusive, which means that somebody else, it's going to be a very long shot. But, somebody else starts using your name on socks, you don't have the protection. Then also, if you end up getting that office action that we talked about, LegalZoom is going to tell you, well, this is how much it's going to cost for us to help you with that office action, if they even help you with it. So then you might end up having to go to an attorney, which is going to cost you more because an attorney is going to tell you, it's going to take me this many hours to, file this argument, and it's going to cost this much, which, you could have saved it if you had actually gone to an attorney in the beginning. But anyway, so, I usually get the argument where people are like, I'm just going to put it off. That doesn't even cost that much. I can deal with it later. I don't need to deal with it. But let's think about it. If you had a clogged sink or if your car broke down, you're going to find a way to get the money, right? So why not do that in this instance? Like, this is your baby. Like, you have put blood, sweat, and tears into it. This is kind of like could be your third, fourth, or fifth child, or even your first, and you don't want to have to go through the whole, well, I had to start my business all over again, or I had to rebrand and it cost me a lot of money, or having to just stop because it just got too expensive and you just can't move forward. So consider using an attorney. And of course, I'm not saying that I'm your attorney, number one, that's my disclaimer. And number two, I'm not just saying this because I am an attorney. It's just because it's more cost effective and efficient to go through an attorney. Attorneys usually charge between $1,000 and $3,000 for their trademark services. Most of them charge flat fees. They also offer payment plans. Some of them do. So it just depends on, which attorney you want to go through, like if you feel like you're a good fit with this attorney, all those things. But what an attorney is going to be able to do to help you is, one, they're going to do a search to make sure that the name that you're trying to use is available. And they're going to do a very thorough search. So that means that they're going to pull a report from a vendor, like a third-party vendor, and it's going to be a very detailed search. It's going to include, if there are any pending registrations, or if there are any registrations that might be similar to yours, like they might have had an S added, or there might be like a phonetic, similarity. It could be, in a foreign language it's similar, or it's like the same. So all those things are going to be in this report. It's also going to include state trademark registries. It's going to have Secretary of State, websites and names that might be similar to yours, domain names, all those things. So the attorney is going to get that report, go through it, analyze it, look at the results, figure out and see if there are any things that you need to be aware of that might stop your application from moving forward, or, the things that say like, hey, we can move forward. There's, very low risk of you getting a rejection based on it being similar to these names. So an attorney also is going to let you know if you even have a name that can be registered. Like, I'm one of these people who I will let you know that does not function as a trademark, and we probably need to look at using some other names, because it doesn't, unless you want to move forward with it, which, that is your option. Like, you have the option if you want to move forward with something that, even though I've advised you that it's a possibility that you might get a rejection, we can do it. I will work with you on that. Because again, this is your choice. Like, you are the one who is making you're paying for the services. It's your choice. I can only advise you on the risk and, what could happen. So an attorney, like, if there's, no issues, low risk of you getting a rejection, that your name functions as a trademark, it's unique, all these things, like, they will help you describe your goods and services to make sure that you have exclusive rights to use those things and that you're protected in those areas. They will also make sure that your application is filled out right, like the proper ownership. And of course, one of the biggest things is making sure that they present the right evidence to show that your mark is in use. This is called a specimen. And the trademark office is very detailed with their specimens, because the main thing that usually gets people in trouble is someone will actually go file a catchphrase and be like, oh, I'm going to start making t-shirts with this catchphrase and I'm going to trademark it. Then they submit a picture of a t-shirt with a mock-up or drawing of the trademark that they plan on, registering, and then saying like, oh, well, this is my mark in use. Number one, a fake mock-up is not going to get you anywhere, because the trademark office actually knows that, and it's easy to see. Also, if your shirt actually just has your trademark on it, it's not identifying the source. It's just a decoration at that point. The source of your apparel or your t-shirt is going to be who provides, like, your brand name, like the company that's selling that t-shirt. So it's not to say that you can't have your trademark on your shirt, like Nike's got Nike shirts, but also I know that the Nike shirt that I'm wearing that has Nike on it it came from Nike. So, like, for example, I'm wearing this Run DMC t-shirt. Run DMC did not make my t-shirt. This is just a decoration. I don't even remember who makes the shirt because it's literally on the back of the shirt. So keep that in mind if you're going to be submitting a specimen or evidence of your products, especially with t-shirts, because this is the biggest thing that usually happens, is you actually have to show that this is not a ornamental or decoration. It is where your t-shirts are being, it's the source of your shirts. So that would be showing like a hang tag with your trademark name, or like the back of the shirt is going to have the trademark name. So it's identifying the source. Like, it's telling me that, okay, this shirt came from this company, and I know this is where I'm going to be able to find it if I need to buy a new one. So keep that in mind. All right. So yeah, that was a lot, I know, but I feel like it's important because it's one of those things that I usually get asked, and I want to make sure that people are aware. So I hope that has been helpful. If you have any questions, or if you need me to kind of go into more detail with something, feel free to contact me, direct message me on Facebook or Instagram. Like I said, I'm trying to get better with Instagram. I'm at Creativa IP Law or Trademark Law Diva. On Facebook, I'm Creativa IP Law. I'm also on Twitter. However, I'm only there to follow. I usually post like once a month. So Twitter is probably, it's not one of the places where I generally am. I'm usually on Facebook at least 2 or 3 hours a day, because that is like my jam. Don't ask why. But anyway, so you can contact me on Facebook. You can go to my website. It's creativaiplaw.com. You can send me a message through there. You can schedule an appointment if you are ready to protect your brand, and if you're ready to move forward based on what I've told you, or if you're ready to, if you want to wait and kind of talk about your options, we can do that. We can, whatever you please. So I will be seeing you all later. Enjoy your Friday. Have a great weekend. See you all for Tipsy Tuesday at 9 p.m. Eastern Time, 8 p.m. Central, where I bring the wine, the IP tips, and we work together and have some fun. All right, so have a great one. Okay, bye.